Good morning, everyone. A very warm welcome to all the participants joining us today for this very special learning session on mediation, a quick guide for young lawyers. My name is Drishti and I'm delighted to be your host for this informative and enriching webinar organized by Law Learning Bench under our flagship program, Courtroom Advocacy Skills Training Program. We call it CASTP. Before we begin, a quick reminder, this session may be recorded by the organizers for academic enrichment. Kindly refrain from recording or distributing any part of this session without our permission. To all the participants, if you have any questions, any doubts, anything that you want to ask us or the guest, you are free to just put your questions in the end of the session. Meanwhile, the session is going on. You can freely just post your questions in the chat box, but do not forget to use #question so that we can differentiate it from your normal thoughts to your questions. Please, I would like to repeat, whenever you're posting your questions, do ensure you have written #question before that. Now, allow me a few minutes to introduce you to Law Learning Bench. At Law Learning Bench, our mission is simple: to bridge the gap between legal education and courtroom practice. Through our Courtroom Advocacy Skills Training Program, CASTP, we focus on transforming students into confident, ethical, and skilled advocates, ready for real-world challenges. So just now I gave you a brief about Law Learning Bench. Let me just elaborate it much further for your understanding. So at Law Learning Bench, it is an educational institution for practical legal training and skill development. The institution is designed to bridge the gap between legal education and courtroom practice. At Law Learning Bench, we nurture a new generation of lawyers. Most of you might be first generation lawyers as well. Most of you might be a mid-career lawyer as well. So you're not just skilled in language, in knowledge, you should also be skilled in practice. You should also be skilled in ethics. You should also be able to articulate and dedicate to upholding justice. We all, lawyers, judges, we all are stakeholders to justice delivery. Now, coming on to objective of this session, to explore how practical courtroom advocacy skills strengthen your legal education. Also to help students build real-world courtroom competence alongside academic learning. Now, law schools, you all have dedicated either 5 years or 3 years to your law schools, and I believe you have strong theoretical foundation. I also believe you have great understanding of legal principles, and you also have knowledge of statutes and case laws, because this is what our law schools teach us. However, is this enough? The laws in book? No, the laws in book is not enough. There is a whole world of law that exists beyond your books. It is called law in courtroom. Now, if I ask you, most of you would be lawyers, advocates, legal students, everybody who's confused either to go for corporate, to go for litigation, to go for judiciary. Now, all of you, if I ask you, how confident are you in presenting a case before a judge today? The answer would be most of you would either be willing not to do that or would be very nervous doing that. So what it is, the difference between a law professional and a legal student. For instance, we are law students, but we want to become legal professional. What exactly is the difference? So the difference is in your law school, you are taught theoretical learning. You have been made to learn how to define culpable homicide and distinguish it from murder. You might be able to do that perfectly, even with case laws and sections. However, in courtroom, the expectations are different. In courtroom, you would be expected, can you prove the accused intended to cause the death? Not merely have the knowledge here, you need to have the application knowledge also. You need to prepare strategy also. You have to come up with real-time case laws, real-time arguments that will favor your stance. So, to elaborate my example, I would like to give you just one simple example. This would be your experience in your law school. So in law school, when your teacher wanted to teach you some concept, they would give you a case law. The case law will feel very easy. The case law, first of all, would be related to just the topic that the teacher is teaching. The case would be very easy. There would be a victim. There would be one who has committed the crime. There would be the judge presenting mostly the judgment in favor of the victim. But does this relate to the reality? It does not. In reality, sometimes you would be provided with complex or sometimes even incomplete facts. The parties would strategically shift. The witnesses would turn hostile. So the evidence that you require sometimes would be so technical that you might be in a position not, you will have to enter into the shoes of some other technical expert. For instance, we lawyers, we have to sometimes enter into the domain of other experts. If we have to use forensic report in our evidence, then we have to go into the technicalities of that forensic report. And I assume most of us have not even seen a forensic report, let alone using it in an evidence. That's exactly the difference. The ideal case that are taught to us in law schools are very simple. They have just one clear answer. And most of your class, if not all, would come up with that answer. This does not happen in reality. In reality, sometimes the facts would be so complex that it would present more than one answer. It would have more than one law. It would have more than one sections. So this is what you have to learn. You need to learn application, analysis, and strategic decision making. Sometimes on real time, you're standing in front of a judge and you're asked a question. Now you have to come up with an answer in real time, also which supports you and it against the opposite party. Then comes the challenges and complexities of young lawyers. So most of you are first generation lawyers, I'm assuming. Most of you already know the problems. We go through confusion, we go through a lot of paperwork pressure, we go through struggle for credibility. Sometimes when we do not know the answer, we start questioning ourselves. This is what the purpose of our webinars is. It is not you, it is how our education system works. They have just made us learn rote learning, book learning. They have just made us think not beyond the books. So sometimes when you question yourself, it's not your problem, it's not your inefficiencies, it's something that you are not taught, something you need to learn, and this is the practice aspect. Then you go through confidence challenge. Why am I not able to do it? Why are others able to do it? And then there are ethical crossroads. So the real cases, they bring tough decisions on integrity. Sometimes you have to act logically, not emotionally, but this is the crossroad that you have to somehow deal with. Then comes other challenges. For instance, when you are asked to prove whether the accused intended to cause the murder. Now here you cannot just have the knowledge, you cannot just have the sections in place and also the case laws. Here your delivery matters, here your courtroom presentation matters, your evidencing matters, what evidence you're presenting in your favor and which can counter the evidence of the other party. Here you have to first draft your arguments in such a way before even presentation before the judges, it's your draft which makes an impression. So you have to come up with the draft. Then you have to gather and organize evidence. Your evidence is not going to be in one place like we are taught in our law school. It would be fragmented and we have to somehow deal with the fragmentation and come up with a logical story-like format which would make sense not just to us but also to the judge, because ultimately it is the judge we are trying to convince. Then beyond the classroom, what you should master to be an advocate, you need to learn to have application, adaptation, preparation, court filing, which is online and offline both. If you have like focused on the world, how it is transitioning, you can understand that we are moving a lot towards this online. I would say online is still the idea of the yesterday. Today, we are even focusing on AI. AI has started making its way in high courts, in Supreme Courts. So you have to be very well versed with not only the online and offline formatting, but also with the emerging technologies that are making their way in the courtroom. Also, if you understand the district judiciary is different, the court filing is different from the higher judiciary. The higher judiciary's court filing procedures are different from the Supreme Court. Also, the various high courts have different procedures among themselves. So the knowledge is very fragmented and something that if you learn to master once, things would become very easy for you. Those things that now probably today do not either make sense to you or you find them very difficult. Then you also need to learn post-listing scenarios. Just when you had an argument before the judges in the end, you have to also be reliable. You need to also be conversant with the rules of post-listing scenarios as well, which are different. High courts are different. Several high courts among themselves are different. District court is different. Supreme Court is different. Then comes building your academic foundation. So something that you already did, something our law schools played a great role in doing so. Somehow they have done one great job, which is inculcating the foundation, the academic foundation they have built for you. You are good with knowledge of law, you're good with the case laws, you're good with statutes, you're good with everything that is provided in the books. The only thing left is the practical application of it. And somehow we cannot blame law schools for that, because practical expectation, they It requires huge training. It requires huge interaction with other stakeholders. Now, if I ask you how many of you even had the interaction with other stakeholders, for instance, police, judges, law experts, the exposure is very limited. So unless you practice in the court or in a courtroom-like environment, it becomes very difficult to even understand whether I'm good with practical aspects or not. Then from classroom learning to court application, what do you require? Translating knowledge. The knowledge that you have already acquired in your courtroom, if you're not able to somehow use and translate the knowledge to make it approximately applicable to your case law and deliver it also to the judge and make him understand that there is no use and no utilization of that knowledge. You might be the topper of your class, but if your delivery is weak, somehow your legal career might suffer. Second comes professional drafting. There are formats and you just need to learn the format. This is just like a puzzle you crack once, you would be an efficient lawyer otherwise. You will be able to frame the drafts for rest of your life perfectly. It's just the beginning that you need to work on. Then comes realistic stimulations. So like I was saying, this is not a classroom, this is the real world. Here cases are complex. Here the parties may not even cooperate. Here you will not, even the machinery, the legal machinery, the police may not cooperate with you always. So something you need to learn about the reality. You need to learn how you work as a lawyer in real life. Then comes the practice with real drafts and documents. So you need to now transition from those ideal cases your teachers taught you from the real cases, which are complex, which are confusing, which depend on parties. Maybe the one facts that you have dealt with in one case may not be applicable to the other client. So it depends on what kinds of clients you're getting. Every case would be like new for you. Then comes connecting theory with practice. So here we are not asking you to just forget whatever you have learned in your law school. We are going to require that knowledge. We just need to teach you how to use that. So your theory, your foundation, which you have already built, we just need to polish that. We just need to give you a direction in what direction you can use the same. You need to have a real world clarity, how things work in real life. You need to learn court operation, how things work in the courtroom. Then you need to learn reinforcing your understanding. Perhaps you would be understanding a concept perfectly. You would understand all the technicalities of it. But you have to also make your client and also the judge understand the same. So it is not just about your grasping capacity, but also the capacity of making the world understand your perspective. Then next comes collaborative learning. So you have to collaborate with various stakeholders. It comes all members of law and order and justice delivery. These are police, these are law experts, these are lawyers, they are senior advocates, there are judges, there are retired judges, and so on. Then I have dedicated enough time telling you the problem, and I have dedicated enough time in telling you where are the gaps. Now I would like to tell you how to fill those gaps. So first of all, the very first basic understanding is stop blaming yourself. If you see somebody doing better than you, just don't blame yourself for not performing as well. There are people who are different from you. Your journey is different from others. So you just need to have a personalized training. That's it. The one wherein the focus is on you specific, on your specific problems, unlike the classroom wherein everybody's focus is same for everyone. The one size fits all approach will not work for you. Maybe it worked earlier. So we have law learning bench has come up with courtroom advocacy skills training program. We call it CAS-TP. It offers a structured module aligned with your curriculum, taught by expert faculty drawn from both academia and practicing bar. It bridges the gap between the law in books and law in practice. CAS-TP, in these 12 weeks on weekend classes, we will ensure that you are courtroom ready and you are ready to deliver your legal knowledge in the real world. We have a structured learning material. We have guest lectures by field experts. We have faculty which include senior advocates, former judges, and legal experts. We also have guest lectures by field experts. And we have specific live expert-less sessions and one-on-one mentorship sessions for you. Your problems might be different from others. You might not be able to share it in front of the class. Fine, we will arrange mentorship one-on-one sessions for you. And there are limited seats and personalized schedules so that we do not focus on quantity but focus on quality. We have limited seats, so we will engage a few students and then we will focus on them. And how are we going to enhance your legal education experience and your career? We will have interactive workshops. We will have live sessions. We will have live courtroom observation wherein we will hold assessment and also the moot courts. Moot courts which are appropriate to real world cases, which should be a high quality moot courts, not your law school moot courts, and would also be judged based on assessments in the end of every module. And then comes the personalized feedback. What you should focus on would be different from what others need to focus on. Perhaps your strong point would be a weak point for others. Somebody's weak point would be a strong point for you. So personalized feedback will help you dedicate your time exactly where you should dedicate it. And also you would realize what your strong points are, so you can keep them at side for some times and focus on your weaknesses. Then comes essential skills for every advocate. Essential skills are legal mastery, research proficiency. Research nowadays also includes technology. So these are not old traditional methods of research. It includes AI also, and it includes everything which is transitioning, something that we might not even know today while we are talking, but would be a new breathtaking technology like AI tomorrow. Then comes the stress and time management. Somehow you will not be provided a week or 2 weeks like you're given for your moot courts in your classroom. In real life, the dates are strict. The stress management and time management would go hand in hand, and you need to learn that. Then you need to learn courtroom presence. Somehow you need to be actively present. You need to learn to take the pressure and not get scared of it, and also come up with a reply. Sometimes that can be from the opposite parties. Most of the time it can be from the judges. Then comes negotiation ability, something which the lawyers should always be good with. This will help you getting your favorable judgments also, and also in your counseling with the clients. Then comes analytical thinking. Using the facts that you already have, give it a shape and make it applicable to the problem is what we call analytical thinking. Then you have to be more transparent. You have the right to know who you would be mentored under. So meet our advisory board. We have Honorable Shri K.G. Balakrishnan. We have Honorable Shri Ajay Rastogi, Honorable Shri S.R. Yadav. Then the CAS-TP program in these 12 weeks is divided into 12 very rigorous, expert-laden, and very well-drafted modules. These are the 12 modules. Now, I would like to remind you again to all the participants, if you have any questions, you are supposed to drop them in the chat box with the hashtag question. We will take them up toward the end of the session. Now, without any further delay, we are delighted to host Advocate Prabha Swami, Advocate on Record, Supreme Court of India. Ma'am has been enrolled with Bar Council of Delhi since 1988 and has served as an advocate on record in Supreme Court since 2002. A trained and empaneled mediator with Supreme Court's MP, NCPC and NCDRC. She also serves on the Supreme Court's Gender Sensitization and ICC Committee and is a founding member of Nivaran. She has contributed to legal publications as well, including CM Rowe's Law of Injunctions and Halsbury's Law of India. Her session is designed to help young advocates, young lawyers, aspiring lawyers, and fresh advocates understand what it truly takes to bridge the gap between mediation law in books and mediation law in practice. Ladies and gentlemen, please join me in welcoming Advocate Prabha Swami. Ma'am, we are truly honored to have you with us. The virtual floor is all yours now.
Thank you, Drishti. I hope I'm audible and visible to everyone.
Perfectly audible.
Thank you, Drishti. So good morning to everyone and a warm welcome to everyone. I am Prabha Swami, advocate on record in the Supreme Court, and I am trustee and treasurer of Nivaran, Mediators of Supreme Court of India. Today, we will not only understand what mediation is, but also how it works in real life, why it is becoming a global movement, and why India's Mediation Act 2023 is a turning point in our dispute resolution landscape. You will all wonder why mediation, because you're all lawyers. You think litigation, corporate work is more important, more lucrative. But mediation is the future of the judicial system in India. And once you are trained in this mediation forum, it will help you a lot in your future life, because it is going to explode. The mediation is going to explode, especially with the coming of the Mediation Act 2023. Now, let me start my lecture. First is mediation, meaning, purpose, and advantages. Mediation is not mini litigation. It is voluntary, confidential conversation facilitated by a neutral person, the mediator. What does this mean? I'm not a judge. I'm not going to reach a decision. Both the parties will talk to each other, and the mediator will help them find a solution which is comfortable and convenient for both of them. It focuses on interests and not positions. Now, what does this mean? Interests and positions. You will think they both mean the same thing, but they don't. Positions are rigid. Interests are broader. Suppose two people want an orange and they go to court and they fight for the orange. The court will give it to one person. So then what happens? One person wins and one person loses. But if you go to mediation, the mediator will ask, why do you want the orange? One person may say, I want the juice of the orange. One person may say, I want the rind of the orange for cooking. In which case, both of them will get the orange, and so it's a win-win solution. So that is the main advantage of mediation, because it focuses on your interest, not on your position. So you may only think, I want the orange, but you may not know why you want the orange. The court won't ask you why you want the orange. But the mediator has a larger scope to ask you, why do you want the orange? So mediation aims to produce consensual, durable settlements. So how do we go about this? Suppose there's a long family dispute over ancestral property that goes on for many years. The mediator makes them talk to each other, and then it gets resolved. Why? Because they want to maintain family ties. So it fosters personal relationships, encourages cooperation, and maintains mutual respect, and it is less stressful than a court. What are the advantages of a mediation? It is faster because they're all time bound. It can't go on for on. You've heard the saying, Tariq pe Tariq, Tariq pe Tariq, but mediation is not like that. It has a fixed period. The mediation has to be done within that period, and you get an extension of a little more period after that. It is cheaper. It is cheaper because every time you go to the court, you'll have to pay your lawyer, you'll have paperwork, so it is very much cheaper. It is confidential. Whatever is said during the mediation, it cannot go beyond the room. It cannot go beyond the room. In fact, even if the mediator makes notes, the mediator has to tally it at the end of each session. And whatever happens during the mediation, it is not told to the court. If by chance the mediation fails, the court is not told why it failed. The petitioner said this, the respondent said this. No, you only said mediation failed. So it protects the interests of all. You can speak what you want. It is highly confidential. It preserves relationship. It is not that one person goes to court, one wins, one loses, because both of you get what you want and both of you can preserve the relationship. It is flexible and parties control the outcome. The mediator does not control the outcome. Both of you talk with the help of the mediator and you control the outcome. And you would have found out that the Singapore Convention has come into existence. Many mediated commercial disputes settle, mostly within a week. That is why Singapore has built a global reputation today as a dispute resolution hub. So you will find that mediation helps people sort out problems. People can sit together, they can talk together. It is a confidential atmosphere. It is in a room. You can have your lawyer present to help you with any legal aspect, or you can just sit. You can sit one-on-one with the mediator and you can decide how you want the process to go on. The role of a mediator. Now, the mediator is not a judge, not an arbitrator, and not a counselor. They're a facilitator of communication. What does this mean? We help both the parties communicate with each other. We ask A, okay, what do you want? We ask B, what do you want? And then suppose A is wanting something which is out of the box. B wants something out of the box. We ask them to come to a middle ground. You will see that in a lot of matrimonial disputes, the wife will want 5 crores, the husband will say 5 lakhs. Then we come to a middle ground and we make them both understand, okay, this is what he can afford, this is what he can give you. Are you okay with this? We do not decide. We do not tell them, okay, take 5 lakhs, take 3 crores. We ask them, we make the positions clear with both of them so that they both can come to an understanding. And what are the main tips for success? A mediator is a neutral and impartial facilitator who manages the process. He will maintain confidentiality, which is the essence of mediation, and declare any conflict of interest. In case the mediator knows any of the parties, the mediator has to immediately tell, I know this party, or I have done a case for this party. No, if you have any conflict of interest, you cannot be the mediator. You must be totally neutral. You must not have any thing to gain from the outcome of the mediation. So that is why you're totally neutral, and that makes the whole mediation process very safe for the parties. And then you have a reality test proposal. So we have a reality test proposal. It helps the parties to understand the strength and weaknesses of their case and to encourage a realistic and mutually acceptable settlement. So you will see that, like I explained to you just now, in a matrimonial matter, it is not just you sit and say, like, I want 5 lakhs, I want 3 crores. You sit with them individually. These are known as joint sessions and single sessions. You sit with them and explain to them, what is it do you want? How do you think it will go forward? If you do not enter into the mediation, you know that you will have to go to court. It will go on for several years, 10 years, 15 years, 20 years. Are you willing for that? Are you willing for relationships to be spoiled? And in matrimonial matters, you usually have asset demarcation, you have maintainability to be given, you have child custody. So all this can be sorted out in an amicable manner, in an amiable manner in a mediation process. In many matrimonial mediations, you will find that the mediation breakthrough comes not from the first joint session, but from a quiet caucus. Caucus means single session, where the spouses expresses concerns they were too afraid to share publicly. If you're sitting together, the husband or wife may be scared to tell confidential things. But when you sit alone with the mediator, you can tell the mediator, okay, this is what I fear. I'm afraid that if he takes my son or my daughter away, he will not give the child back. I'm afraid that he will have him for 2-3 days, he will give him a lot of gifts and toys, and the child will move away from me. In which case, you can talk to them, you can make the husband understand the wife's fears, you can make the wife understand the husband's fears, and you can try to sort it all out. And ultimately, they decide what they want to do. The mediator does not tell them, aise karo, vaise karo. No, you don't tell them that. They have to decide what they want to do. So they are in control of the outcome of the whole process. We do not control the outcome of the whole process. Then we have to create a clear mediation brief. What is a clear mediation brief? We have a lot of things in mediation, those known as Batna, Vatna and Malatna. Now, if you have Batna, Vatna is a best alternative to a negotiated agreement. What course to follow if mediation fails? The mediator will help them understand if a settlement is better than their alternatives. Like, for example, okay, you don't settle in the mediation, then what is your option? You will have legal costs, time, etc. Like in a contract, you can decide to go to court or enter into a contract with another company. So during mediation, you can say, okay, I don't want to settle with you, I'm going to court. Or I can enter into a contract with another company. So you let the other party know, okay, these are my options. In which case, the other person might also adjust what they want and try to come down a bit. So you set the ground rules early. You use joint sessions strategically. You have joint sessions and then you have single sessions. So you can initially when you start, you have joint sessions. You talk to both the parties. So both the parties know what the other person is thinking. And then you have single sessions, which is private, confidential. Whatever is said in the single session is not told to the other party unless you get permission from the person with whom you're holding the single session. And then you can use these single sessions to break deadlocks. Because you can tell them, so he says he can give you only 5 lakhs. How much are you willing to come down? Or she wants 3 crores. How much are you willing to come up? So this helps to break the deadlock. And then you draft clear settlement terms. When you draft clear settlement terms, you will put everything in writing. If suppose it's a matrimonial matter, there are cases pending between the husband and the wife. Then you tell, okay, this is the case. Husband has filed a divorce petition. Wife has filed domestic violence case. Wife has filed for maintenance, and wife has filed for whatever that. So everything is put in the mediation settlement agreement, and you tell them, okay, all these cases, all these matters can be resolved once you settle the matter. It's not that you have to go to this court, family court for the divorce case, this court for this. All the matters can be settled at the same time through the settlement agreement. And you can ask them to withdraw all their cases. And once the settlement agreement is entered into, if it is a court annexed mediation, the court will record it. Or if it is otherwise also, can be enforced like a court decree. So it gives full power to the parties that once you have, with knowledge, with your consent, you have signed this mediation agreement, then it is like a court decree. It's not that it's just a piece of paper. Okay, I've signed it. Now, I said I'll give 2 crores. Abhi dene ki zarurat nahi hai. No, you have to give it. You have to give it because it becomes like a court decree. Especially after the passing of the Mediation Act 2023, once both the parties agreed to sign the mediation agreement, both the parties sign it, their lawyers sign it, and it is fully settled, then it is as binding as a court decree on you. Then, so how does the mediation start? So first you go to the mediation. Now mediation, you have private mediation or you have court annexed mediations. You will see now in Supreme Court, lot of matrimonial matters, once it comes up, it comes in the form of a transfer petition. The judge will say, please go for mediation, try mediation in the Supreme Court Mediation Center or in whatever, suppose High Court Mediation Center. So a lot of high courts have mediation centers attached to them. So you go to them and you go to the mediator, one time and date is given for them. So then you go, the mediator calls both the parties either physically or virtually, because after COVID, there are a lot of, now you find that the virtual mediation is also allowed. So what happens? The mediator will explain the confidentiality, that this is totally confidential. What happens inside these walls will not go outside these walls without your permission. What happens in single session will not go outside the single session. He'll explain the process and the ground rules. Ground rules are that you must be polite. You must be, when one person is talking, do not talk, do not get angry, do not throw things, and there's no recording. There's no recording of the process, the procedure at all. Then there you have the opening statement. Each party shares their perspective. In a like for example, in a workplace dispute, employees often feel heard for the first time. They're too scared of their bosses to talk. They will not tell in open, like they're scared of losing their job. They're scared of losing the respect of their colleagues. But what do you do in a mediation? You can have, in a single session, you can say, I am not feel heard. I'm being overworked. I don't have work-life balance. So then the mediator will tell it to the other side with the permission of one of the parties. So you'll be heard for the first time. Then joint discussion. You can identify core issues. So suppose we're talking about a contract clause, but the real issue is delayed payments. So you say, okay, we're talking about this clause. The person goes to court saying they have not complied with clause so and so of my agreement. But they'll say, but in a mediation, there it will go only on legal terms, as per the statute, as per the law, as per the rules. But here you can say, no, I am okay with being in the agreement with this person, but he delays the payment by 1 month, 2 months, 3 months. I'm out. That has a cascading effect on my work. So when you are in a mediation, you have that freedom to talk to them to settle it. Caucuses, what are caucuses? There are private meetings. So whatever you don't want to say in the joint session, that is in front of each other, you have the single sessions. They are known as caucuses, where you can talk to each other, where you can tell the mediator, this is my real problem. This is what is happening. Suppose it's a matrimonial matter. His mother interferes too much, but I don't want to tell in front of him because he'll think I am the problem. Or if it is a vendor may reveal cash flow difficulties and confidentiality. So all this you can explain and tell in the single session, which you can put it in a proper way to the other party. Like they're having she seems to be having some problem with your household. Is there any way you can solve it? Is there any way you can talk to your family members? And in a mediation, everybody is welcome. Suppose it's you can have your parents come in, you can have your sisters come in. It's not like it is only the lawyer and the party who has to come. People who have an interest in the problem, who can help you find a solution, are most welcome to come and do it. Then you can negotiate options. What does this mean? You can create solutions. Okay, like for example, like I told you, suppose she has a problem with his mother. Okay, she will stay separately from us. We will stay separately, but close by. I'm okay with that. So you can find solutions which help both the parties and save the marriage also. And then end of it, what happens? Either an agreement is signed or mediation ends without a settlement. And if it ends without a settlement, you just say mediation failed. You do not say this one said this one said that. So your full privacy is maintained. And even the lawyer who takes part in the mediation is not supposed to go to court and say, this happened, like we were willing to give this much, but they did not accept, or we were willing to renegotiate the terms of the agreement, but they were not willing. So everything is totally confidential. You're not supposed to say what happens in the mediation process to anybody else. Then what are the tools in mediation? Interest-based negotiation. What does this mean? I've already talked to you about position and interest when I told you about the orange. So interest is there and position is there. Position is rigid. Nay, I want only this. I will not go. But then when you look inside, you have a different interest. So you can, if you work on your interest, and then mediator will help you. It is not that the mediation is only 1 session or 2 sessions. In fact, I have conducted mediations which have gone up to 15 sessions. And then at the end of it, we have found a solution. We have entered into an agreement. Then you have reality testing. What is this? Patna, Malatna. Like I told you, Patna is the best alternative to a negotiated agreement. Vatna is the worst alternative to a negotiated settlement. It shows the party what they would have to deal with if a mediation does not end with a deal. You may lose opportunities to deal with the company always. So what happens? You do not enter into the agreement. The company will say they are being so stubborn, they are being so rigid. Okay, with this point, at this point, we will not enter into any further contract with them. We will not give them any of our work-based solution, work-based problems. We will not enter any. We will not allow them to have any tender with us. And so that is known as Patna, worst alternative to a negotiated settlement. So reality testing helps here. So suppose the court doesn't accept your document. What is your best alternative? Both of you go to court. He is talking about a clause in your contract, but you have a different opinion. What if the court does not agree to that? Then you lose the job, you lose the work, you lose the litigation. So you must think about, suppose I do not enter into this mediation agreement, then what is the worst thing that can happen to me? I will lose everything. So mediation helps you control your destiny, helps you control the course of a litigation. And the next thing we have is Malatna, most likely alternative to a negotiated agreement. This provides the most probable outcome to enable parties to reach a mutually acceptable agreement that is better. So this is better. So then you have caucusing, which I've already told you. Caucusing means single sessions and online mediation platforms. Now, even as per the Mediation Act 2023, you will find that you are allowed to have online mediation, and this is also considered a part of the mediation process. Because during COVID-19, online mediations rose dramatically, and many businesses discovered that digital mediation is sometimes more effective because stakeholders sitting in different states or countries can attend instantly. Even you find like a lot of mediation take place nowadays, somebody is in abroad or somebody is in a different state. So for them coming to suppose it is a Supreme Court based mediation, for them to come from, say, from Karnataka and to come from Maharashtra, it's easier to have a virtual mediation. And nowadays it becomes easier. People are more comfortable with the online also. So they're able to talk more freely also. And it's not that, you are stiff in front of, physical only is better. Virtual also, people have become in tune with the virtual mode since the COVID-19. And so this also helps them. So virtual mode is also very, very effective means of solving mediation. In fact, many of my mediations, they're online throughout. Like I told you, 10-15 sessions. And during the signing of the agreement, of course, the parties have to come. But it is not that if it's virtual, it is ineffective and only physical is effective. Virtual is as good. Physical is, of course, better because of the body language. You can see each other, you can ask each other questions. That is a different matter. But virtual is also quite an effective mechanism for solving mediation problems. So suppose you have difficulties. How do we address them? Mediation is simple, but it is not always easy. You have power imbalance. Now, what do you mean by power imbalance? One person is more assertive. One is more dominating. One is more aged, and there are language barriers. So how can the mediator address this? You can have more single private sessions and reframe issues so that all parties can understand. So actually the first thing as a mediator, what I do when parties come, are you comfortable in English or Hindi? What would you prefer the mediation to be conducted in? And sometimes because I am from Tamil Nadu, people will say, I am from Tamil Nadu, can you talk to me in Tamil? So one party will talk in Tamil, one party will talk in English. And suppose one person is not very fluent in English. The private sessions, we can talk to them and then translate it and tell it to the other party that this is what is happening. So power imbalance is there, which can be sorted out by the mediator. Then you have hidden information or weak bargaining positions. Suppose there's a large company and a small supplier. The single sessions, the caucus sessions, allows a safe environment for the weaker party. So the large company is very big, it has a lot of money. The small supplier, especially you will find in MSMEs, the supplier, the buyer is a huge corporate, the MSMEs are small. So they do not want to fight with them because they want to have further business with them. But in the single session, you can ask, what's the problem? What happened? And then they'll say, like, we gave them good parts, but they said, no, it is not proper. And they refused to take it, which led to a cascading effect. Our credit line got hurt. So please talk to them, tell them, like, please accept this consignment. And from next time, I will try to see that this quality control is maintained. Then the mediator establishes equal participation. So he says that it is not that I give one person half an hour and one person 15 minutes. I give them both equal time, half an hour, so that no person feels that he is not being heard and no person feels that the mediator is siding with one person. The mediator is totally impartial. We hear both the sides and you both decide what you want to do. I don't tell you, I can only tell you, this is the path, this is what this person said, this is what this person said, and you can come to a solution. We are there to guide you, we are there to help you. We are not there to judge you. And sometimes there's lack of trust, there's hidden information and missing stakeholders. This becomes the biggest problem during corporate mediation because parties must have actual authority to settle or access to those who do. Some people come, they take part in the mediation process, but they say, we can't sign. Then we said, like, what's the point of spending so much time and energy on this when you don't have the authority to sign? So either you have somebody in these mediation sessions who is in a position to sign, or who can call someone or be in touch with someone. Okay, this is what the other side is proposing. Shall I accept it or not? Then you have cultural and language barriers. If parties speak different languages or come from diverse backgrounds, mediators may use culturally aware techniques or interpreters. So you can have interpreters. Suppose a person comes from Maharashtra and I do not know Marathi, then I can use an interpreter to talk to them, to be there, to talk to the party and find out what is happening. And then we have staged agreements. So in a staged agreement, the parties agree on specific steps and timelines for resolving a dispute over time, rather than all at once. So suppose it is a matrimonial matter. The husband says, okay, I'm willing to give you 50 lakhs, but I can't give you all at once because I have to break my FD, I have to break my PF, all that. So I can give it to you in installments. Like I will give you 5 lakhs now, after 2 months I'll give you another 20 lakhs, after another 2 months I'll give you 20 lakhs, then 5 lakhs. So when you're signing the agreement, you have all these clauses in them. So it is, the final agreement is signed only after all the stages are completed and it is agreed upon. So you say, okay, I'm agreeable for this. Can't you give me like 15 lakhs now? So he says, okay. So all these things, you have staged agreements. So at every stage, you have different stages where you finalize and you're able to do your payments. In this case, suppose it's a payment, you have to give some money. So you decide, both of you mutually agree, okay, we'll give it in installments. So what is the process of a stage settlement plan? Stage 1, an initial set of actions is agreed upon with a specific deadline for completion. Stage 2, another set of actions or payment is scheduled for a later date. Like I said, first I give you 5 lakhs and then I give you 15 lakhs. Final agreement, the overall settlement documents is finalized and signed after only all the stage actions are completed and verified. So you have to decide when to give, what to give. And sometimes if you want, you can have the agreement signed after all the money is given. Or since I told you now, it is once a mediation settlement is signed, it is as effective as a decree of court. You can sign it before itself. So why do you use a staged agreement? It is useful for complex disputes where resolving everything at once is not feasible. Suppose you're not able to give 50 lakhs now at the moment. So what do? You say, okay, I will give it to you in stages. And there is financial or logistical constraints. So like I told you, over installments over a period of time. So it allows the parties to resolve certain issues first, building momentum towards a full resolution. It provides a clear step-by-step roadmap to the final resolution with each stage documented in writing. So you have each stage documented in writing, and it is totally between you both. You both decide what you want to do, how you want to do, when you want to do, and once you sign it. But you have to be very careful, because once you sign it, it is final, and you have to adhere to it, adhere to the all the writings in the settlement agreement. Then you have now the Mediation Act 2023. You know, the Mediation Act came into force in September 2023. So the primary goal of the Act is to give a final and binding status to a mediated settlement agreement. So what is a mediated settlement agreement? Mediated settlement agreement is when you both decide, okay, these are the stages, we both have agreed on this. So that is known as a mediated settlement agreement. In the Act, it is known as MSA. Once it is in writing, it is signed by all the parties and authenticated by the mediator. It becomes full and binding on the parties and any person claiming under them. So you cannot say, I have signed this MSA and okay, tomorrow I can go back on it. No, it is one of the primary goals of the Mediation Act 2023 is to give a final and binding status to a mediated settlement agreement. Then what are the salient features of the Act? What are the important features of the Act? There is voluntary pre-litigation mediation. What is pre-litigation mediation? Many parties don't know that litigation will take 15 years, 20 years. So you have many statutes which now provide for a pre-litigation mediation. So this Act, excuse me, this Act encourages parties to voluntarily attempt mediation for civil and commercial disputes before approaching a court. This differs from the earlier bill which proposed mandatory mediation. So now a lot of statutes have pre-litigation mediation, including the Commercial Courts Act. So if the money is more than rupees 3 lakhs and you don't want any interim injunction, then you have to go for pre-litigation mediation. Then there are certain matters which are not suitable for litigation. Not all matters can come for litigation. I will not explain each this thing to you, each dispute to you, but each category to you, but I will tell you, like cases involving vulnerable parties like minors, deities, and persons with intellectual disabilities, criminal offences. Certain offences which are compoundable can be referred to mediation, but this mediation is not considered a court judgment and it still requires judicial review. Then proceedings against professionals, like against lawyers, doctors, they are not come under the Mediation Act. Tax-related disputes, third-party rights. Suppose there are two parties, but whatever you decide will affect a third party, then that will not, you cannot send that for mediation. Land acquisition, including involving land acquisition and compensation returnable under that. Proceedings before special tribunals, government disputes. And then the central government also has the authority to notify any other subject as being unsuitable for mediation. Now, this Mediation Act came into force in September 2023. It promotes institutional, community and online mediation and mandatory registration of mediators. Settlement agreements become enforceable like court decrees. Like I told you, it is not just, okay, just two of us are there, you cannot enforce it. No, you can enforce it like a court decree. Earlier, mediation had no independent statutory backing. Now, we have a modern framework like Singapore, Italy, and the US. So, and why is now mediation so important? Courts have over 4.5 crore pending cases. Even if 10% move to mediation, the impact is revolutionary. And you will find that the cases get resolved faster because there are 4.5 crore cases. The time taken for each case to reach is around 4-5 months. But if at least even 10% is settled by mediation, then it becomes faster. Accessibility to the judicial justice becomes faster. Then we have the Singapore Convention. The UNCITRAL Singapore Convention makes international mediated settlement agreements enforceable across borders. It was adopted in 2018 and came into force in 2020. India signed the same on 7th August 2019, but has not yet ratified it. What does that mean? That is, we are bound by it, but ratification is the formal process that makes it legally binding. The Mediation Act 2023 was only for domestic mediation. and does not incorporate the Singapore Convention. The Singapore Convention applies only to international commercial disputes. Like for example, suppose you have an Indian company and a Dubai distributor, they resolve a dispute through mediation in Singapore. After signing, if one party does not comply, the other can enforce the settlement directly in the courts of a signatory country without filing a new lawsuit. So this gives mediation international credibility subject to arbitration under the New York Convention. Now we have certain cases which promote mediation, which are basically Supreme Court cases. So I will just give you the highlights. I'll give you the bullet points of each. One is the Salem Advocate Bar Association. The citations are there on the slide. So the Salem Advocate Bar Association judgment encouraged alternative dispute resolution. The model rules for mediation. AFCON structure, courts must consider referring suitable matters to ADR mechanisms like mediation. Motiram versus Ashok Kumar, confidentiality is essential. Nothing said in mediation should leak into litigation. Patil automation, pre-litigation mediation is mandatory in commercial disputes. This is section 12A of the Commercial Courts Act. B.S. Krishnamurthy, lawyers must advise clients to opt for mediation. So, to conclude it, mediators don't impose outcomes, they enable them. It respects relationships, culture, and dignity. It is the most dynamic tool in reducing the judiciary's burden. The Mediation Act 2023 is a vision that will shape the next decade of conflict resolution in India. If courts deliver justice, mediation resolves and restores harmony. With this, I conclude my lecture, and I give the ground back to Drishti. After her speech, then we will have a question and answer sessions. And like she said, if you have any doubts, please put it in the chat box with the hashtag question, so that if there are any doubts, any questions, or you can raise your hands. If I'm able to solve them, I will definitely do that. Back to you, Drishti.
Thank you, ma'am, for the insightful pointers, especially on the responsibilities of a mediator, challenges faced during mediation, and the steps of the mediation process. Now, before moving to our Q&A session, a gentle reminder that Law Learning Bench has launched its CAS-TP program with limited seats. CAS-TP program offers structured modules aligned with your curriculum taught by expert faculty drawn from both academia and practicing bar. This program bridges the gap between the law schools and the practicing lawyers. CAS-TP, it has 12 weeks tenure and weekend classes. It has a structured learning material, guest lectures by field experts, limited seats, live expert-led session and mentorship one-on-one sessions, and faculty which include senior advocates, former judges, and legal experts. So how will we enhance your legal education experience? We will have interactive workshops, live sessions, live courtroom observation, personalized feedback. What is essential for you to be an advocate is all included in CAS-TP. It includes legal mastery, research proficiency, stress and time management, courtroom presence, negotiation ability, analytical thinking, and excellent communication. So before you ask questions about who you would be mentored under, this is our advisory board. It includes Honorable Shri K.G. Balakrishnan, Honorable Shri Ajay Rastogi, Honorable Shri S.R. Yadav. The modules of CAS-TP will cover various aspects required for you to be a courtroom-ready advocate. This includes introduction to advocacy and trial process, client interview, interaction counseling and case building, courtroom procedure and behavior, legal drafting, oral advocacy, witness handling, including examination in chief and cross-examination, then evidence handling, bail appeals and revision, then understanding negotiation and ADR, which a part of which was mediation, which ma'am just brilliantly covered. Then courtroom etiquette, technology in advocacy, which includes e-filing, virtual court hearing, and digital tools. Then also mock trials and performance, a dedicated 12th module for only assessing your performance and telling you what are the areas you need to specifically work on. After this course, you would be provided one certificate which you can use in your professional journey. It can add some value to your CV, and it can also add advantages while negotiating for any kind of cases or jobs, anything. Then comes the letter of recommendation by the law learning bench professionals. Then comes the skills that you would be earning that would make you a courtroom ready advocate and will transition your journey from being a lawyer to an advocate. Then it will transfer ultimately to you to advocate. I would say only the bar practicing certificate does not guarantee your legal professional career. You need to learn how to apply law. You need to learn how to be courtroom ready. You need to learn not only the presence in like physical courtroom, now the virtual courtroom as well. And you aspire to be a skilled legal professional, we are here to help you become one. We already have a batch of more than 70 students and we only have limited seats available. So I would request you to register yours before we close the batch, because we believe in quality and not quantity. Once we have the appropriate seats filled, we would not be accepting any other enrollments. So I request everybody to please hurry up. This is our 4th or 5th webinar. We have received a lot of response from other people, a lot of people in waiting also for the next batch that we would launch. So we are working on that as well. Now, before further delay, I would request everybody to just raise your hands and unmute yourself, and you can ask your questions. If you're not comfortable unmuting, so post your questions with #question, and I would take them up and ma'am would be happy to answer them.
Okay, I have a question from Vaibhav Jain.
Ma'am, you're not audible. Can you be a bit louder?
Is it better now?
Yes, ma'am. Perfectly fine.
I have a question from Vaibhav Jain. Can an advocate attend mediation proceedings? Definitely. In fact, in the Supreme Court, we have these court annexed mediations. The parties come with their lawyers because they're comfortable with their lawyers. Sometimes they come with the local counsel. Suppose they come up to the Supreme Court. That means they've gone through the trial court, high court stages. Sometimes they come with their local lawyers and they all sit together. Like I told you, anybody can come for the mediation, the family members, whoever you're comfortable with. So you get a sense of, you're not scared, especially parties coming for the first time to the court, they get scared. So if you have these people, they give you the strength to attend the mediation proceedings and to be calm and to be, frank. And so that helps the outcome also. Then Vaibhav Jain has also asked, how to begin career as a mediator? What are the steps and strategies? So as of now, we know that mediation and conciliation is a compulsory subject in the law schools. I think from 2021, 22. So, but you'd learn only the basics in that. So basically what you have now is this MCPC, that is the Mediation and Conciliation Project Committee of the Supreme Court. They have a 40-hour training program to train mediators, to train advocates to become mediators. But this is only for advocates. So advocates can enter, but you have to have a tenure as a law student or just starting out, you cannot have. You have to have an experience of around 10 years to enter this program to get into the training sessions to become a mediator. And then there are a lot of now private institutions like IAMC in Hyderabad. A lot of private institutions are there which which train you in mediation, including Nivaran also, which train you in mediation. But MCPC is the most, it is because it is founded by the Supreme Court of India, by the Legal Aid chapter of the Supreme Court of India, by the NALSA of Supreme Court of India. So for that you need some experience, but others you can join any private institutions, and then if you are, you're good at it, then they can provide you work also. Then I have a question from Harsh Singh. It's the same thing, from where can I start my career? Okay, this is the same as Vaibhav Jain. Then Anup Kumar has asked, what to do if you refuse mediation? If you refuse mediation, then it just goes back, settlement failed. You can refuse mediation because it is a voluntary process. In fact, during the whole process, you can tell the mediator, at any stage you can tell, no, I do not want to continue this mediation, I want to go back to court. Sometimes the parties are so angry, they would rather fight for the next 10-15 years than try to sort it out. So once you say, no, I don't want mediation, or even after the mediation process starts, in between you say, no, I don't want to go through the mediation, then it ends there. The mediator will send it back to the court or to wherever, or the mediation has failed. So it ends there. You cannot force anybody. Next question is by Astha. As a third-year student, I do have mediation as one of my varied subjects. And I would certainly like to ask that putting in court annexed mediation for, like, if a mediator becomes aware through confidential caucus that one party is intentionally withholding material facts that would fundamentally alter the fairness of the settlement, then does the mediator have a legal or ethical duty to disclose or terminate the process? And if confidentiality is absolute, how is procedural fairness ensured within this matter? And if you take neutrality is absolute, how is justice protected? Because as per mediation law, it clearly mentions neutrality and confidentiality, but does not give a clear hierarchy when they tend to clash within it. Like I told you, one of the basic tenets of mediation is confidentiality. If something is told which will prejudice the other party and you told it in a private session, you cannot tell it to the other party without prejudicing, without the permission of the party. Sometimes this may lead to unfortunate results, but the mediator is not there to judge it. You cannot. So you have to maintain the confidentiality. You have to maintain the neutrality. You cannot just tell it without the permission of the party. And if this affects it, then you can indicate, you can't directly tell the other party that, this is there, like, why don't you study a bit further? You cannot tell them, this is what the other party told me, but you can indicate to them, okay, like, why don't you study a bit more? Why don't you take a little help from your legal practitioner or from somebody close to you? Study it a bit more and come back to me. But you cannot break the confidentiality. Then Roshan Lal has said, many law students focus heavily on litigation. How can we start building mediation related skills early in our legal education? Like I told you, litigation and corporate work is very much more lucrative now. To go into the mediation field, it's just an evolving concept. It will take a few years to come. So if you have just started, you're in your 4th year or 5th year and you're just finishing your law career, then once you need to get trained as a mediator. That is that 40 hours you have, as per the MCPC, you have a 40-hour training session. You have to do that, but that's only around after 10 years of becoming a lawyer. So you have to wait it out in these 10 years. In between, you learn the mediation skills. You can attend mediation seminars, mediation lectures, and then slowly build it up. You can't start you can start as a lawyer as soon as you finish law college and pass the bar council exam. But mediation is not like that. You have to undergo the training process, and then there are steps after that also. But if you're interested in it, and once the Mediation Act gets more notified, all the sections have not been notified in the Mediation Act 2023. Once it is notified, we'll get a clearer idea, because they will take these, they're going to have these mediation councils. So how you can join the mediation councils, once all the sections get ratified, notified, then it will give you a better idea of how you can become a litigator little earlier on also. Then the next question I have is from Pankhuri Pankaj. Are there certain checkpoints that a mediator can develop for a successful mediation? One, definitely you need patience, because like I told you, I have conducted sessions for around 15 sessions, around between 1 to 2 hours each. You must have patience. You must not be influenced by what one party is saying. Sometimes you hear one party, you get influenced by that. You must maintain your neutrality throughout. You must have the maturity to know that there are two sides, like in a coin, there are two sides. So it's not that one side is right, one side is wrong. You must take both sides into account and be neutral, be confidential, guide them towards a outcome which is beneficial to both of them. Okay, you enter into this mediation, all the pending cases can be settled, all the custody matters can be settled, all the maintenance matters can be settled. And then you don't have to go through litigation. You don't have to go for next 10, 15 years of litigation. You have to make them understand that. So I think the basic thing is patience and neutrality and maintaining confidentiality. So then we have Roshan Lal. Could you share some real world examples where mediation saved significant time or resource compared to traditional litigation? Like I've given you the example during my lecture of transfer petitions. One husband files for divorce. That is just the starting point of the litigation. He files for divorce. And then suppose he files for divorce in Bangalore. The wife is in Delhi. She files what is known as a transfer petition in the Supreme Court. Please transfer the proceedings from Bangalore to Delhi. Then what do? Sometimes the court will say, please refer it to a mediation, Supreme Court Mediation Center. So there you talk to the husband, you talk to the wife, you say you're just starting the litigation journey. You want to fight it out, you just stop it. You just stop it here. You can resolve everything in this. You start the litigation process. One person will get the divorce, one won't get the divorce. The person will go to the High Court, from the High Court to the Supreme Court. It will take 10, 15 years. Your energy, everything will get dissipated. So this, I've seen it in so many times that this pre-litigation mediation really helps, especially I'm telling you in matrimonial matters where you can sort it all out at the initial stages. So these are real life examples which I have been privy to, which I have been a mediator for. Then Anup Kumar has also asked, what do you do if you refuse mediation, which I have already answered. Then Roshan Lal is saying, I am interested in setting up an online dispute resolution, specifically a mediation center of my own. Could you please clarify what the process of registration looks like under the new mediation framework? Are there specific licensing, permissions or regulatory compliances I should be aware of? Additionally, who is legally permitted to establish such a center and who can serve us as mediators within it? I would really appreciate some guidance on the practical and legal considerations involved. Like I had told you, the Mediation Act has not been fully notified. All the sections have not been notified. Certain sections have been notified, and we have to await the Mediation Act being fully notified. So before we can, I can guide you through this. So I'm afraid you will have to wait for the Mediation Act to become more evolved and be more notified. Roshan Lal says, in reality, mediation panels and institutional rosters often get filled through networks or references. What mechanism does the new codified framework provide for to ensure merit-based appointment rather than connection-based ones? Like I heard Drishti saying, many of you are first-generation lawyers. I am also first-generation lawyers. If you are hardworking and you are sincere, then it really doesn't matter, you have connections or not. Of course, connections do matter. Like you have all these Nepo babies, but they also have to work hard. Initially, you get the step in having connections, but if you're not good, you're not competent, you're not sincere, you cannot progress further. So just try your best, try your hardest, and there are always avenues for hardworking and sincere people. And I think that's all the questions we have. So I hope I have clarified your doubts and questions. Thank you so much.
Am I audible and visible?
Yes, Drishti.
Thank you so much, ma'am, for your deep experience and real-world perspectives will surely guide us all in shaping our advocacy skills. A big thank you to all the participants for joining us today. Please do not forget to follow Law Learning Bench for our upcoming webinars and the Advanced Courtroom Advocacy Skills Training Program, CASTP. Just a small reminder that we have shared a feedback form which is pinned in the chat box. If you have joined through the laptop or computer, it would be accessible to you. Otherwise, we would be sharing the same via WhatsApp. So please do not forget to fill the form and submit the same to us. It will help us understand your expectations and what you expect next and how to improve ourselves. Again, thank you so much. Please stay tuned for the next equally interesting and interactive webinar. Thank you so much. Thank you, ma'am.
Thank you.
Thank you, Prabha ma'am. Thank you.
Thank you, Panditji. Thank you.
We all are thank you.